this evidence, to me, as has been offered by the prosecution, has no other possible explanation or hypothesis save that which is being offered by the prosecution, that it is Matthew Chirabu who killed Desire Mirembe.
Last week, the High Court in Mukono found Dr. Matthew Chirabu guilty for the grisly murder of his girlfriend, Desire Mirembe Jemima. However, by the time he was convicted, it is believed that Chirabu had slipped across the country's porous borders and is currently hiding outside the country under a new identity. The prosecution adduced evidence showing that on the night of 11th July 2015, Chirabu, who had a rocky relationship with Mirembe, lured her into a death trap at Cafe Java's Oasis Mall. Under the pretext of resolving their differences amicably, this was the last time Mirembe, a medical student at Makerere University, was seen alive. At about 10 p.m., Chirabu, acting upon his impulsive rage, drove Desire Mirembe in a car towards Jinja on Kampala-Jinja Highway, branched off 50 meters off the highway into Lugazi sugarcane plantation, where he slit Desire Mirembe's neck. Local residents recovered her body on July 11, 2015. Chirabu later reported to the police and was arrested. Through a charge and caution statement, he confessed to have killed Mirembe.
This evidence is contained in the recorded video PX11 and the confession statement PX21 and is corroborated by all the evidence that I have been reviewing. The confession of the accused contains details of how the accused connived and participated in the murder of Mirembe Desire. In the video recording, the accused is clearly seen leading the investigating officers to the scene of crime. There is no iota of force or machination in the recording. He is seen in a jovial mood and even is seen voluntarily taking turns to correct the police officers where they reach a wrong conclusion in certain aspects of such a detail that could only be known to him. He is so enthusiastic in pointing out certain aspects of what had happened. He is seen at one stop pausing to ask for forgiveness, saying he is a born-again Christian and he regretted for what he had done to murder Desire Mirembe. The evidence in the video recording corroborates the written confession evidence. The same evidence is supported by the DNA findings that the items found on the body of the deceased, like the Nika C2, is associated with both the victim and the deceased. The evidence corroborates itself. It is the accused who was with Desire between the days of 10th and 11th when her death occurred.
Relying on 15 witnesses and Chirabu's confession, Justice Henry Kawesa convicted the accused in absentia, and as part of the evidence, he relied on Chirabu's confession and the charge and caution statement he made at the Central Police Station. A confession is defined as an unequivocal admission of having committed acts amounting to a crime. A confession or statement includes not only admission of the offense, but also admissions of substantially all incriminating facts which constitute the offense. In the video footage, Chirabu is seen leading a team of detectives to Nakumatt Oasis Mall, where he picked up the deceased and later led them to the scene of crime in Lugazi to demonstrate how he murdered Mirembe. The judge revealed that, as a way of disguising his plot and creating a false alibi, Chirabu, barely after killing Mirembe, visited her hostel and sent messages to her relatives. He later dumped her phone at the Chitezi garbage dumping site to cover up his tracks before going to church. The convict remains on a warrant of arrest. However, his absentia has renewed the debate on bail. The right to bail is a fundamental right as Article 28 of the Constitution provides, and it's within the purview of a judge to grant it or not. However, Section 15(3) of the Trial and Indictment Act provides for exceptional circumstances under which bail ought to be granted for capital offences like murder. Amongst the exceptional grounds includes grave illness certified by a medical officer of the prison or other institution. The other two grounds include a certificate of no objection signed by the Director of Public Prosecutions and the infancy or advanced age of the accused. Matthew Chirabu, who is 26 years, is not of advanced age. Was he suffering from any grave illness that couldn't be treated by a medical officer of the prison? And was this illness certified so that his case could fall within this exceptional ambit? Did the DPP's office grant a certificate of no objection?
No, in Matthew's case, the office of the DPP did not grant a certificate of no objection to the grant of bail. We actually objected to the grant of bail, and we presented the fact that there were no exceptional circumstances to warrant the grant of bail.
The spokesperson of the office of the DPP says that it is often frustrating when judicial officers release suspects on bail.
By the time the office of the DPP decides to object to the grant of bail to a suspect, it is because we believe that we have reasonable grounds to suggest that this suspect should be in prison during his trial. And so when such a suspect is granted bail, then it leaves a bitter taste in our mouth. And it's worse when the suspect actually jumps bail. It is even worse when the suspect cannot be rearrested, just like Matthew's case.
There is also no codified body of rules by judicial officers to grant bail. This is what has touched off a combustible debate about when to grant or decline to grant bail to suspects. For instance, in 2020, 2 High Court judges denied granting Belgian national Bernard Glazer bail on grounds of advanced age and sickness. He was 73 and was suffering from stage 4 cancer. He later died in prison. The president has, for instance, vouched for a constitutional amendment that denies suspects in capital offences and terrorism not to be granted bail. But capital offences have been weaponized to target politicians, and there are fears that this would flout the doctrine on the presumption of innocence. In the extreme, whereas suspects who are politicians may not be granted bail on grounds for their bail, other suspects of capital offences, where prima facie evidence has been adduced, may walk scot-free. Does the case of Chirabu fall within this travesty of justice?
It would be helpful to have parameters to guide the exercise of the discretion by judicial officers and to ensure uniformity in the manner in which bail proceedings are handled by them. It would also be helpful if the criminal matters were heard expeditiously.
In the determination of who can get bail, there are certain conditions that must be fulfilled. And that is up to the judicial officer to satisfy himself or herself that this person, once given bail, will not jump bail. But of course there are cases when this has happened. That's not to say that bail should be denied. It's important to guarantee someone's liberty once he or she becomes or comes into conflict with the law. Now, there are different schools of thought. There are people who argue that once someone has offended, he must go through the full trial. If he's acquitted, well and good. If he's convicted, he serves a sentence and must not enjoy the right to bail. But that school of thought fails on very many counts. One is that all of us are potential offenders. And we know that the criminal justice system in Uganda is not effective or has weaknesses. There are weaknesses in investigations, there are weaknesses in prosecution, there are weaknesses in the trial process, and as such, since the practice here is that one has to be arrested before investigations are complete, the right to bail gives an opportunity to the system to ensure that the investigations continue while this person exercises that temporary relief. However, at any point in time in the trial process, the bail could be cancelled.
For a case which was cause-listed in 2015, judgment was delivered 7 years later. By the time of the judgment, Chirabu had graduated from medical school and got employed at Mulago Hospital. He had also filed an application to have his passport returned to him so that he could travel to the United States to undertake his master's. Though court rejected the application, it's not clear yet whether he obtained his passport through underhand methods or received another through forgery to enable him travel. He was also able to conduct a traditional wedding. Judiciary spokesperson Jameson Karemani says the human resource requirements for the judiciary ought to be addressed so that expeditious trials are conducted.
There are so many implications if a case is not handled in time, including people taking the matter into their hands because they wait, there is nothing happening, they decide to do their own things. And when you look at all these capital offenses, most of them are a priority. If it's a murder case, for example, the relatives of the victim want to see justice. If it's a defilement, the victim wants to see justice. So at the end of the day, you realize that all cases need to be prioritized. And to prioritize them, we need to look into those issues of financial resources and human resource. That is recruitment of more judges and also availing a bigger budget to cater for these sessions so that cases are handled in time. So if they are not in the long run, there are various implications, there are various effects even on the economy generally.
Livingstone Sewanyana, the executive director for the Foundation for Human Rights Initiative, says the debate on bail remains contested.
In principle, the grant of bail is a discretion, as I said at the beginning. Secondly, it is based on an assessment, and of course, no one should be unnecessarily denied that right. But then, on the whole, there must be clear guidelines to follow by judicial officers. That is the reason why the judiciary has come up with these guidelines, and the guidelines must be adhered to, because of course there will be a tendency, there could also be a tendency that in exercising their judicial independence, judicial officers may not want to strictly adhere to the guidelines. That should be to a large extent avoided in order to deny anyone the right to bail, but at the same time to deny that argument that bail itself is not a right that should be enjoyed by all.
In 2009, his organization filed a petition before the Constitutional Court contesting, amongst other sections, in the Trial and Indictment Act that created exceptional circumstances in the granting of bail. Foundation for Human Rights Initiative argued that these sections contravened Article 23 of the Constitution. Justice Esther Kisache ruled that whereas court is supposed to bear in the mind the rights of an accused person when considering his or her bail application, court should not lose sight of the needs and interests of society to prevent and punish crimes committed within its midst. This article imposes on courts the duty to ensure that they do not only consider the rights of an accused person applying for bail, rather, the court should also consider the interests of society at large. Sewanyana says, though there are loopholes suspects exploit to jump bail, it shouldn't be a justification to abolish bail.
Judicial officers take into account, one, the offender. Who is the offender? What's the nature of the offense? What are the consequences of this action? How will the public react if this person is granted bail? And are there chances that this person is likely to abuse the bail once granted the bail? He or she will actually, observe the bail terms? Now, that in itself creates a basis upon which a decision then is made for the judicial officer to grant bail. But the most difficult issue here in granting bail is the exercise of the discretion. Should I or shouldn't I? And am I satisfied that this is a case that merits bail? Of course, in all cases, bail should be granted, but there must be reasonable grounds upon which it is granted, and there must be a clear assessment as to whether the bail terms will not be abused.
The Chiza BCJ constitutional reference case did away with the need to prove exceptional circumstances for the grant of bail, and so judicial officers can now grant bail to suspects without proof of exceptional circumstances. And the Office of the DPP has no recourse because the Director of Public Prosecutions has no right of appeal in such decisions or against such decisions.
Was it because he came from a wealthy family, as bail is monetized? And does granting or rejecting to grant bail heavily weigh against indigent suspects? The judicial officer perhaps believed that Chirabu would abide by the bail terms.
We have the Trial on Indictments Act and the Magistrates Courts Act that qualify the provisions of the Constitution regarding the grant of bail, and they provide for the circumstances under which someone should be granted bail. You can see that the law recognizes that there are individuals that need or may need to be granted bail, depending on the circumstances of the case. So really, it's judicial officers that grant bail based on the circumstances of the cases that are before them. And this is because they have discretion to grant the bail or not to grant the bail.
Judicial officers should exercise this discretion very cautiously or very sparingly, because a capital offense in its nature is so grave that it should be, the bail should be granted very sparingly. That's why the Constitution has made provision for one who has committed a capital offense. There's an assumption that at least should be on remand for at least 180 days, and has made provision for mandatory bail. That after 180 days, there's an assumption that the investigations are complete, the trial can take place, and therefore this person, if this has not happened, then this person should not continue to be abused, but should be given relief and granted the mandatory bail. That's not to say that the person becomes free or has been acquitted, but still facing the legal process. Only that, because the system is not quick enough, this person should not continue to suffer. Let him or her be given the benefit of getting the mandatory bail while the investigations continue. So, in the case of Chirabu versus Desire, one has to examine the arguments, has to examine the consideration and find out whether, based on that, the judicial officer was justified to grant bail. But there is always a strong belief that in all cases, whether they are petty or capital offenses, bail should never be denied.
In principle, bail is a constitutional right which is within the discretion of judicial officers to grant or to deny. But while exercising their discretion, judicial officers should follow clear guidelines. Today, the country bears the collective guilt of the grisly murder of a one promising young girl, Desire Mirembe, who was eager to scale the heights of medical practice. However, her family is grappling with emotional scars as the person behind her death is in hiding away of jurisdiction court where he's supposed to be serving a sentence.